2000. And I want to add by saying that when it comes to the regulations of legal induced abortion, we have an act, which is Genetic Health Act. And the provisions in this act states that this person, well, she or her spouse acquires genetic, infectious, or psychiatric disease detrimental to reproductive health. And the second reason is anyone within the fourth degree of kin, relative of herself or her spouse, acquires a genetic disease. And the third, by medical consideration, pregnancy or delivery may cause a loss of life of this person. And the fourth is by medical consideration, there is risk of teratogenesis. And the fifth, if it is pregnancy as a result of rape, lured into sex intercourse or in sex intercourse with a man prohibited from lawfully marrying her, then this woman can ask for the induction of abortion. And the sixth reason is if the pregnancy or childbirth is likely to affect this woman's mental health or family life, then if a pregnant woman satisfied either one of these provisions, then she's allowed to legally abort the fetus.
What I gather from the report and the replies to the list of issues and questions is that while technically abortion is not legal, but there are many exceptions. There are many conditions under which abortion can be obtained. The figure that you have given here of 70,000 per year, from your report again, I gather, and you must correct me if I'm wrong, they are legal abortions. Women have fulfilled the conditions necessary. Because you've said it's difficult to get data on illegal abortions because there's no voluntary reporting required, so they are legal. I have a couple of questions about this. The issue of abortion is never pleasant. It is, of course, a reproductive right, and women must have the right to have that control over their pregnancy, to continue with the pregnancy or not. Nevertheless, it is not a pleasant context. It's not at all a pleasant context and may pose health problems. So we have to take a very holistic approach to the issue of abortion. We always have to also ask, why do women have to go for abortion? Prevention of conception is always a good alternative. So one question we need to ask is, what is the range of reproductive health services available to women in order to protect their life as well as their good health, and is there adequate reproductive health services, including contraceptive services, that is available? Is there enough information about it? That is one question, so I'd like you to answer that question. Secondly, where there are conditions under which women can obtain abortion, are the services available to all women who may need it? Is there, in other words, the question of affordability and accessibility of services? Do the public hospitals provide these services at reasonable rates so that all women can avail themselves of the service? That's a second question. And a third question that I have is, where abortion is allowed and the conditions are fulfilled, can women make this decision for themselves? Or apart from the fact that they have to be medically certified that they have fulfilled the conditions, do they have to refer the matter to any family member, to their husbands, if they are younger women and not married, to their parents? Is the permission of another relative, such as husband or parent, required, so that there is no autonomy for the woman concerned to make this decision? Because the conditions are very stringent. Although there's a list, a range of conditions, it's still not giving her the abortion is going to be very detrimental to her health. It affects her mental life, it affects her health, it affects many things. It's a consequence of rape, and so on and so forth. So these are some of the questions I have. When pending on your answers, I may have a follow-up question. Did I ask too many?
Please.
Thank you very much for your questions. Now, in terms of services that are provided to this type of women, first of all, we can discuss prevention. So we work with a Ministry of Education to improve education on sex, especially for young people. Secondly, the Department of Health provides consultations and advice to young people. We want to make our consultations and services accessible to the young people so that the young people have a good knowledge about their health and how to protect themselves in terms of health. And if women get pregnant by accident or unexpectedly, we work with the Ministry of Interior to provide pregnancy advice to the pregnant women. And throughout the country, we have 39 hospitals and clinics that help to educate young people on contraception, whereas Ministry of Education with the health agency continue to provide training workshop, and many hospitals and clinics are part of the joint effort to provide good education on good sex education for young people or for people in general. We also have a hotline and a website, both of which provides sex education. And if women have questions on abortions, they can call the hotline or come to our website to look for information. Next, as to how the abortion services are accessible to women. Again, people have to satisfy the provisions of the Genetic Health Act, and the doctors must be OB/GYN specialized doctors. So in terms of abortion services or abortion consultations, I believe the services are quite accessible. And for young women or underage women who need to conduct abortion, then the guardian had to agree before the abortion can be conducted.
So what about married women? Do they have to get husbands' permission? That is one question. And whether married, unmarried, no, unmarried would go to, is there any relative that has to permit any woman who is asking for abortion? And I was not clear whether you answered the question on the affordability of the services. Do public hospitals provide this at a reasonable rate?
Okay. Abortion for married women, well, based on the Genetic Health Act, yes, it requires the consent from the spouse. As we review this act, we discovered that it is inconsistent with the two covenants. So in the revised Reproduction Health Act, we made some changes because we know that the two covenants state that when women are to decide whether she is going to abort the child, she needs to consult with the spouse. So we are in the process of revising the Genetic Health Act, and we revise the part which requires the consent of the spouse into to only the notification sent to the spouse. And our universal health insurance can cover abortion cases if it is due to medical condition. If it is not a medical condition, then people have to pay for it themselves. If it is an RU486 case, then the fee is about $8,000 to $15,000 NT dollars. Maybe for some low-income families, it is a financial burden.
So you are saying that the fee charged could be a financial burden to low-income women, that is denying them the right to adequate health services, and this needs to be considered. Secondly, if I understood you correctly, you said you realize that needing permission from the spouse is a violation of the articles of the two covenants, and you are in the process of, you intend to revise your Genetic and Ethical Medical Act. But I heard that it will not be permission but a notification. Did I hear that correctly? Can you explain that, please?
Yes, that's correct. The woman still has to notify her spouse. After the amendment, if the family members or the spouse has exercised domestic violence against the woman, threatening the life of the woman, then the woman does not have to inform the family members or spouse of her decision to have abortion. In other words, if there's a risk of life for the woman in informing the husband, then she does not have to inform her husband. As for the cost of abortion, this may be a burden for low-income family. In this regard, we do have social welfare system from which they can seek help.
Benefits for such women. So that is a good idea. But I just need to say something. I think the state is, this is the question of privacy really, which is in the later article. The state is intruding a great deal into personal lives of people because it's laying conditions such as you don't have to notify if there is domestic violence. If there is no domestic violence, then you're regulating the relationship, of the couple, which is something that you need to consider whether you need to do this. There are other jurisdictions in other countries of Asia where this issue has been discussed, and the courts have ruled that pregnancy, the continuation of pregnancy, and the risks of pregnancy, the risks of childbirth is entirely borne by the woman, even in a marriage, in a family, and therefore she has control of whether she should go ahead with abortion or not. This is not to say that in any good marriage there would be a consultation between husband and wife, but I don't think that should be regulated by law to say she has to notify or she has to get permission. I don't see much difference between permission and notification. I really don't see that much difference. So this is something that you need to consider, the right of determination over her own body. By not giving it to the woman, there is violation of in my view, violation of the covenants, and that is a comment I want you to consider. There is just one more issue in this area, and that is the issue of abortions that take place because of sex pre-selection, the predetermination of that the fetus is female, and therefore the decision to abort. Could you tell us whether this happens in Taiwan, the sex pre-selection through abortion of the female fetus?
好，这个部分谢谢委员我们来说明。
Thank you. In fact, in many Asian countries, parents tend to prefer male babies. The same is here in Taiwan. According to data in 2004, the sex ratio between newborn babies is 1.1 to 1, whereas the normal ratio should be 1.02 to 1 between male and female newborns. So we have tried to improve the situation. Until last year, the ratio has dropped to 1.04 to 1. In fact, when it comes to the third child, usually this ratio gap would be even narrower. So the Ministry of the Interior has done a lot of work to improve the situation by amending the law related to inheritance rights and taking the surname after the mother or the father. So we are also looking into methods of amending the medical laws, such as the Genetic Health Act, to see how we can change the situation. Take Genetic Health Act, for example. One of the provisions has to do with the pregnancy likely to affect the pregnant woman's mental health or family life. Some women used to use this excuse to abort a female fetus, but we have banned that. Again, the physician law also prohibits the physician from performing abortion surgery based on the sex of the fetus. If you are a laboratory technician and you help to perform such sex screening, then it is against the provisions of the Laboratory Technician Act. So these are legal protections. We also have a surveillance system to monitor in each city and county the ratio between male and female newborns. The threshold is 1.06 to 1. If the ratio is much higher than that, we would look into that situation. Moreover, we also visit the OBSGYN clinics and hospitals at least 4 times a year to look into this matter. And if there are any advertisements or promotional information about sex screening for fetus, we would perform investigations. And when it comes to the artificial reproduction, we also prohibit sex screening and selection beforehand, before the embryo is implanted. Of course, this issue has much to do with people's recognition of the role, sex roles or gender roles. So last year was the year of the dragon in the Chinese lunar calendar. So we produced some promotional material to highlight the value of female and male on the same level. And at the same time, we also provide more education to make sure that no female fetus will be aborted simply because of the sex.
I'm very happy to hear what you just said and the efforts you're taking to stop this practice of female feticide. And I congratulate you on that. I just want to point out that although what you're doing goes against social preference and the value system of the society, but you're willing to educate society that discrimination against the female is a violation of a human right, and these rights are universal rights. In the same sense, I just want to link this to the previous discussion on death penalty, where I sense some kind of hesitation that the majority of people still want death penalty, and you're hesitating to go against that value system. But here you're already doing it. In another area, you're doing it. You're going against the social value system because there's a universal right of non-discrimination against women. So you can do it. It's a question of whether you see the relevance of what we are talking about. Yeah. Well, very good. I'm happy to hear what was said.
Thank you very much. That brings us to the end of Article 6 as far as I am concerned, unless there are other issues. And I realize that we are very late. So I hope that we can go a little bit faster through Article 7, although there have been quite many questions. But let's try to be very much to the point. I do understand that under the Taiwanese criminal code there is no explicit crime of torture, at least not in accordance with the definition of torture in the United Nations Convention Against Torture. So just my question is the government planning to establish a specific crime of torture with all the elements? That means not only inflicting deliberately severe pain or suffering, but for a particular purpose, such as extracting a confession or information, etc. Is this planned, and if so, when do you envisage the enactment of a specific crime of torture in your criminal code?
According to Article 126 of ROC Criminal Code, a public official charged with the custody or conveyance of prisoners who commits an act of violence or cruelty to a prisoner shall be sentenced to imprisonment for no less than 1 year, but not more than 7 years. If death results from the commission of the offender shall be sentenced to life imprisonment or with imprisonment for not less than 7 years. We also have similar provisions in the Criminal Code of Armed Forces. If we are talking about torture, it is not necessary involving violation of cruel or inhumane punishment, as long as it makes people feel that they are being cruelly treated abstractly, then that would be defined as torture. So that's how we look at torture. May I say a few things on behalf of the Ministry of Defense? According to the Criminal Code of Armed Forces, sometimes an officer may bully his subordinates. In that case, we would consider it a torture offense. And in fact, we would have severe punishment, not only for the offender, but also for the offender's supervisor. Therefore, we do have very stringent provisions on these instances.
Proceedings, I meant we have the written answers of the government, so there's no need to read them out again. So I try to be very specific. Having read it, I conclude that there is no crime of torture. Of course, there are criminal provisions in the military code and in the ordinary code, criminal code, but they are not in compliance with the definition of torture developed by the United Nations. Now, I'm saying this because impunity for torture is a major problem in most countries of the world, and according to all the information we have, also in Taiwan. And in order to fight impunity, the first step is to criminalize torture. We need a very specific crime of torture with all the elements of torture, not just as it is in Article 126 of the Criminal Code. And if a person commits torture in all its brutality, deliberate infliction of severe pain or suffering in order to extract a confession, then this person should not be sentenced to a fine or disciplinary punishment. This is a serious crime, and the person should be then sentenced to long-term imprisonment, like for other violent crimes, like murder or armed robbery. That's the idea. So that's why my question was, is the government satisfied with what it has, or after having ratified the United Nations covenants, does the government plan to adopt a crime of torture in accordance with United Nations standards? I know that you have not ratified the Convention Against Torture, but the Human Rights Committee also, when it defines torture, takes into account the legal definition in Article 1 of the Convention Against Torture. That's the reason, the background for my question. But am I correct that so far there are no plans, no plans of enacting a specific crime of torture in the Criminal Code of Taiwan. Is this correct?
我补充说明一下，这个可能不太一样的观念。
Oh, I think there's a difference between concepts, and we think the spirits and the elements of cat has been included in our criminal code. But maybe you are saying that some of the content have not yet been reflected in our criminal code. And we have a task force which is going to review the content of cat. And we have the plans to incorporate cat into domestic law through an implementation act or through a multilateral treaty act or through the conclusion of treaty act. But we may make some reservation. For example, we may reserve on the need to set up a special committee for torture. But we will have to further discuss that.
I have read under paragraph 61 that in relation to corporal punishment in schools and also in the military, but in schools that as many as 109 teachers nationwide received punishment for corporal punishment and undue discipline in 2011 alone. Can you state what type of punishment these teachers received? I guess it is not a criminal punishment. I guess it's a disciplinary punishment, but perhaps you can explain.
Thank you for your question. In our education basic law, it stipulates that schools shall not impose corporate punishment. So the punishment for more than 100 teachers is administrative measures. If it was not serious, then we record a reprimand on their record. Or if it is too serious, then these school may stop hiring these teachers. So these are the relative forms. These are the relevant forms of punishments that can be imposed on teachers if they impose incorporate punishment on students.
We put the same question to the representative of the Ministry of Defense. If there are cases such as the one mentioned in paragraph 62, would the punishment also be a disciplinary punishment under the military regulations, or would it be a criminal punishment?
Let me put my answers in two parts. Because we have a military academy, and the students in this academy are not military officers yet. And if these students bully each other, then they will be regulated by school regulations. The students may be expelled, or there might be a reprimand on their records. As for the managers or officers of this academy, or if the bullying or torture happens in armed forces, then we will use our Act of Military Education or the act that regulates armed forces to discipline these officers or teachers. And in 2000, there had been 9 cases which were punished by the act. So one of the cases is that the officer forces one of the soldiers to keep running while knowing this soldier had some injury on his leg. Or there was another case while the officer asked the soldiers to do too many push-ups that lead to physical damage. So both of these cases were punished.
Anybody in recent years been punished by a criminal court for an act that can be considered an act of torture, whether it's now under Article 126 of the Criminal Code or any related provision? As a police officer or a military officer or any other security personnel.
报告委员，在检察机关，我们今天来是没有这样子的案例以上报告。
In police department, there hadn't been cases like that. And under the Ministry of National Defense, there had been 9 cases, as I mentioned. There was another case in prison. The prison officer punished a prisoner by asking the prisoner to smoke 3 cigarettes at the same time. And Article 226 in our criminal code was invoked to punish this prison officer. And in the past 2 years, there were 9 other cases while the military officers bullied the soldiers, and therefore they were punished by our law.
Punishments.
I didn't have detailed information for each case. Well, for example, in the prison case, the violation was on Article 226. So the offender was sentenced to 1 year and 2 months because it was a minor crime, and these 2 officers had a 2-year probation. And as for the 9 cases that I just mentioned, I do not have a detailed information on the forms of the punishments yet, but can I be allowed to submit the information tomorrow to you?
Thank you very much. It would be very kind. So I understand all those 9 cases, the persons were punished under the criminal law, under Article 126. So it's not a disciplinary punishment, it is criminal punishment.
Right. It's in the criminal, it's in the armed force criminal code. So some of them were sent into prisons, and some committed minor offense, and therefore their sentences were deferred. But they were punished under the Armed Force Criminal Code or Act.
We had problems with interpretation. You said there were cases, but again, the police officers were sentenced under Article 126 of the Criminal Code, or so what were the kind of punishments?
That's right. The police officer is punished under the criminal code if the police officers bully or torture prisoners or extract a confession, then this police officer is punished by Article 126 under the Criminal Code.
The question was to the practice. In the last 5 years, how many persons have been sentenced for torture and punished under the criminal code? Have there been any cases, and if so, how many, and what were the sentences?
因为我们从
From since 1998, the governments want to stop a convention by torture. So we had a regulation to ask all the police officers to record or videotape continuously their interrogation with the suspects. The police agencies accommodate this policy. So since 2002, we ask all the police agencies to have modern interrogation facility and room, which are equipped with tape recording capacity. So in the past several years, there have not been cases that you were asking for.
Since 1998, not one case of torture occurred by the police. Is that what you're saying?
Punished.
是的。
That's correct.
In response to question 24, I read that it's towards the end of paragraph 63, but I guess this is more correctional facilities. There were a total of 94 cases in 2009, 106 cases in 2010, and 80 cases of torture complaints in 2011. But I don't know what happened with these complaints. Have they all been unfounded, or have they been have they led to any kind of criminal investigation and or prosecution?
The statistics you are seeing here are submitted by the correctional facilities. The 96 and the 186 cases, that these are the numbers from 2009 to 2011. These cases are general complaints in their general life. So these are general complaints, not complaints against torture. And if we receive these type of complaints, we provide several complaints approaches or channels for the inmates. And the correctional facilities have set up complaint boxes to receive these complaints. And these boxes are located in places which are more confined, so other people will not see if someone is submitting a complaint. This is to allow the inmates to express their complaints or to submit their complaints freely. If they submit the complaints, we ask the high-ranking officers not to impose any restrictions on the submission. So the complaints that are mentioned here at corrective facilities are complaints are not complaints against torture, are not complaints against bullying. They are general complaints. When correctional organizations receive these complaints, we guarantee that these inmates will not be punished. We have a monitoring system to guarantee that. And the shadow reports mention Chen Jingyi case, but we think that case was not as serious as a torture case. But that indeed was an administrative omission. So the officers involved and the section chief in that case were imposed upon administrative punishment, but it was not criminal punishment.
It means no torture complaints, but also no ill treatment, no corporal punishment. So corporal punishment only takes place in schools, in the military, but not in prisons, is my conclusion, or by the police. Is my conclusion correct? You have not received any complaints since 1998 or since 2006. So it's a practice only in schools and in the military. Is that the conclusion we should draw from the information you are providing us? Because again, of course, NGOs would not agree with this kind of conclusions. So I put all those questions also having the information that we received from non-governmental organizations in my mind.
We cannot guarantee that there is zero case of corporal punishments, because corporal punishment can be mental or physical. And our criminal code stipulates that, the elements to constitute corporal punishment are quite strict. So as I said, we cannot guarantee 100% that there's zero cases, but we cannot. So maybe there are cases when the correctional agencies, when they're too harsh on the prisoners, and these people will be subject to administrative punishment. There had been many cases where the people who violate the regulations are subjected to administrative punishment.
Mr. Chairperson, may I restate that in the military, there were 9 cases where the perpetrator were sent to go through the criminal trial. And I will give you more detailed information about these cases tomorrow. So all I'm saying is, yes, it happened, but there are few in numbers. For example, the examples I gave you, that the officer asked the soldier to eat ice cubes during a winter day, that's, again, going to be punished by criminal law, not really just by administrative punishment.
In the list of, in the answers to the list of questions, question number 25, where the question is, have there been any cases or complaints of excessive use of force by the police which may amount to cruel, inhuman, or degrading treatment? In paragraph 69, last sentence of the government's replies says, video recording should be used throughout the questioning during any of the following circumstances. and Now, one of the reasons why video recording is required during questioning is precisely to monitor whether the questioning is deteriorating into a cruel and degrading form of treatment. So the video recording is it deters. Maybe it's a translation problem to the English language. I have a little concern when I read that sentence saying video recording should be used. You're not stating in the replies with certainty that video recording is used. So is video recording consistently used during questioning? Because it says should be. It's a good thing to do it. That's what it means. So maybe you can tell us whether video recording is consistently used, and if video recording is not used during a questioning, you don't know what's happening. So my question to you is, can you tell us with some level of certainty that video recording is always used during questioning by the police?
Yes, we do that throughout the questioning. Video recording and audio recording. And all these tapes will be submitted to the prosecutorial officers.
I think we're compressing together several issues. One is, can you tell us in what types of cases that are being investigated is audio recording required? That's one question. A second question, in what kinds of cases is video recording required? The third is a question of fact. To what extent, in your experience, are these legal requirements, whatever they are, actually carried out? So there are two legal questions and at least one or two sets of factual questions. So I'm unclear what the answers are. You don't require video recording in all cases, do you?
Well, allow me to explain. According to the Code of Criminal Procedure, Article 101 and 102, during the questioning of the suspect, there should be continuous recording, audio recording of all cases. But this is not the same for continuous video recording. So for all cases, audio recording is required. Only when necessary, continuous video recording is required. As for judicial officers, what they do in practice, maybe we can ask my colleagues to provide additional information. According to the Code of Criminal Code, continuous audio recording is required, and for certain cases, continuous video recording is required. So as long as the equipment is in place, we usually would have continuous video recording. In other words, in most cases, audio and video recordings are made.
You're among the most advanced jurisdictions in this respect, and I think it's quite an achievement. I haven't heard an answer to what extent in practice this is consistently done, or is it a problem to get the police to comply with that, or the prosecutors. Your law is good. It's not clear when video is necessary, but it's very good. I'm now asking practice. Is practice a problem? When I listen to your discussion of how rare it is for torture to be used in interrogating suspects, it sounds too good to be true to me. It defies human experience, not only in the United States, but in other countries. It's a beautiful picture, but I don't believe it. Now I'm asking you to address this other problem in a realistic way.
If I may just add, I have been 6 years United Nations Special Rapporteur on Torture, and I have been on official mission in also quite a number of countries in this region, including the People's Republic of China, including Nepal, Sri Lanka, Indonesia, etc. And also, to be very clear, I don't have information, and I am not suspecting that torture is widely practiced in Taiwan. But whenever a government or a chief of police or a prison director is telling me torture, ill treatment just does not exist in my country or in my prison or under my police supervision, and we have never heard any cases of torture or ill treatment, or not even no records of excessive use of force by the police, it doesn't exist, then I get very, very skeptical. Because, as Jerry Cohen just said, no police system in the world consists only of angels. It is, I mean, excessive use of force is when you arrest a person and the person is resisting the arrest, you can use force. But you should use only the force that is absolutely necessary to effect the arrest. If you have the person and then still kicking or beating him, this is excessive use of force. If you are dealing with a demonstration that is becoming violent, of course the police has the right to use force, but only proportional. Every non-proportional use of force is excessive. If there are no records, it means that the supervision doesn't function or the complaint system are totally ineffective. And that's the question that I put, or we put, in paragraph 24. We have doubts whether the complaint system is effective or the internal supervision. But I take it, I just would be happy if perhaps also in the later stage we could receive more information about internal inspection units, about might also that has led to disciplinary punishment. It's possible. Usually, as I said, torture should not lead to disciplinary punishment. It should always lead to criminal punishment with appropriate sanctions. If the police is just using a little bit more force than necessary, this is not a crime. That happens everywhere, but still it should be recorded, and there should be a proper procedure, and there should be at least a warning against this police officer. And of course, if we come to paragraph 26, and that's the last one that we can do today, the State report also explains that confessions extracted by torture shall not be admitted as evidence. But then if you read the shadow reports of NGOs, they refer even in death penalty cases to a number of cases where it was established that persons were sentenced to death on the basis of a confession extracted by torture. I admit that this is some time ago in those cases, but still, for instance, Chiu Ho-jun, who spent 23 years in detention, was only finally convicted and sentenced to death in July 2011. And he is still on death row. But it has been established that he was tortured, and under torture he confessed. So also there are doubts whether the absolute prohibition of using evidence extracted by torture has been complied with. And there's also a question about the adequate remedy. Would it be a remedy to commute his death sentence into imprisonment, because probably a person who will be executed and who is sitting on death row will not be able to do much with monetary compensation. So let's perhaps finish this discussion. If you would like still to say something on the general issue, where is the bottleneck? Are the complaints procedures not functioning well? Are the internal inspection mechanisms not functioning well? Or is Taiwan really the only country in the world where torture and ill treatment just doesn't exist?
I think what we are trying to put across is that we understand that governments don't promote it, don't encourage it, obviously discourage it through legislation, through training, through policies, but it happens sometimes, somewhere frequently, somewhere less frequently. But then what comes into play if it happens? Does the government take action against these people? Does the government bring them to justice? Does the government take disciplinary action? In which cases does it take disciplinary action? In which cases does it take criminal action? And has that indeed happened or not? Because if that has not happened, we then presume that torture has not happened. And that is a little difficult to swallow.
Well, we cannot guarantee 100%. There's no such incidents. We, of course, follow the principle of presumed innocence. If the officers are involved in this torture or offenses, usually only two people are present on the site, the victim and the perpetrator, and then you fall into a predicament. So why do we require continuous recording of the questioning? This, of course, is to ensure the accuracy of the transcript. Secondly, if I'm an officer and I want to kick this defendant, I would switch off the recorder, but that, of course, will leave a trace. There's one case in which the officer failed to turn off the recorder, and the officer was recorded to say, "I'll kick you, I'll hit you." And indeed, this is a case that happened more than 20 years ago. So continuous recording, audio recording, and continuous video recording. Well, I think when it comes to video recording, you have to think about the equipment availability. In another well-known case, the defendant was arrested And when the case was presented to the court, the prosecutor failed to attach a videotape, and this was rejected by the court because of the failure of the prosecutor to present a videotape. And I remember there's another case where the investigator smoked in the interrogation room, and the defendant filed complaint later saying that I am a non-smoker because the questioner smoked. I was badly influenced by the smoke. As a result, the confession was denied in the court on that ground. So these are all lessons we can draw from. So there are many rumors out there different from the records we have at hand. But at the government agencies, we do everything we can to prevent the occurrence of torture and extracted confession.
I thank you very much for the discussion. Perhaps also, if we continue here tomorrow upon reflection, if you would like to provide us also other statistical information about cases of torture or ill treatment, which might also be degrading treatment, that have been investigated, similar to the defense and the education department, also by the prison or police department. I am aware that we are very slow, so we really have to speed up tomorrow.
I have to finish my portion before
Yeah,
in the morning.
and I am extremely grateful once more for our interpreters. I realized that we didn't have any breaks. I originally wanted to have a break in the middle, but then we were so much engaged in the death penalty discussions that then it was too late. But I hope that we can do that tomorrow. Thank you very much. We meet again tomorrow at 10. And as I said, let's try from both sides to speed up the proceedings so that we can discuss all the remaining articles of the Covenant on Civil and Political Rights tomorrow morning and afternoon. Thank you very much. Have a good evening.